I hope there aren't too many sore feet in the audience, but I hope everybody really enjoyed the entertainment yesterday evening. Look, I am absolutely delighted and privileged to have as our final keynote interview Gail Slater. Gail, you were relatively recently, I think, back in March, appointed as Assistant AG of the Antitrust Division, the United States Department of Justice. You come with a phenomenal reputation across a number of areas, not just in antitrust, but your advisory roles to then Senator J.D. Vance, your advisory role previously in the White House, and obviously prior experience at the FTC and in private practice. We are absolutely delighted that you've been able to take the time to come to Edinburgh at such a busy time for you. I know you have literally pretty much been more than multitasking with the litigation that's going on back in the States, and we are absolutely fascinated to hear from you. So let's kick off if we can, and perhaps it would be great just to start to hear a little about your sort of general takeaways from this first ICN experience in your role.
Thank you, Sarah, and congratulations to you. I mean, this is a huge undertaking. It's my first ICN, and it is, I can see, a lot of work for the host, so congratulations to you on a job. Very, very well done. I was joking just before we were coming on stage that Sarah must feel like a bride at a 3-day wedding at this point, and so it's not easy to be on all the time, and you've done a really tremendous job. So
we've had the benefit of excellent wedding guests.
There you go.
Thank you very much.
The guests are everything, particularly if they're willing to dance to Scottish music. So, so you didn't just have a wedding; you had a Scottish wedding. Absolutely. Yeah, having been to one or two of them, I know they throw a very good wedding. So. So I have 3 takeaways. So first is just again to say I now understand fully the power of this network, and we all lived through COVID because we're all old enough to remember 2020, and there is no substitute for in-person. We all learned that lesson, and so this is a very powerful network, and of course we at the DOJ are honored to be a part of it. So. I also wanted to recognize our new international deputy at the Antitrust Division, Dina Kalai, who I know is a friend to many of you. Dina informed me yesterday that her first ICN was in 2007. And some of you may not be old enough to remember 2007, that's a while ago. So, and of course, thanks to Linda Marshall, who's sitting next to Dina for all of her hard work. They are the glue that binds ICN together. I think we'd all agree on that. So my second takeaway is, and this is sort of connected to the idea that 80% of life is showing up. So 80% of ICANN, I think, is just showing up and being there. You may not talk to everyone. You may miss a meeting or two. Apologies to the OECD for this morning. But the other thing I've realized is that it can be challenging to do a day job and be here, and so that caught up with me last night. And we will talk a little bit about the 2 Google searches litigations that DOJ is involved in. They are complex litigations involving many, many witnesses. Just to give you some context, we're wrapping up our Google search remedies trial today, and I got an email from the trial team last night sort of summarizing the work involved. It involved 30 witnesses. That's just for the DOJ, whether they were examining them in a direct or on cross-examination. It was preceded with 6 months of discovery, so depositions and document review and expert reports and all of that good stuff. 2 months of expert discovery. And they, at one point at their peak, did 40 depositions in 40 days. That's really something for anyone who knows what a deposition in our system looks like. It's like eight hours of questioning. So that caught up with me last night, but I turned up for 70%. Okay. My third takeaway, and this is a little bit more high level, but as Sarah referenced, I've done antitrust, but I've also sort of zoomed out from that and done more broadly economic policy. And so one thing that I've learned from the EU counterparts, also from Sarah, is that governments worldwide are looking at ways in which competition authorities can be a lever or a tool in economic growth. And so I just wanted to talk about that a little bit, and then I have an idea I wanted to pose for the group. So I took from Sarah's strategic review and then the Draghi report in the EU system, that this was a goal more broadly. How do we stimulate economic growth and innovation in our systems, and what role does competition play in that? You have your 4 Ps, so you have process and predictability,
pace and proportionality.
And proportionality. And so I wanted to talk a little bit about those. Draghi doesn't have the snappy 4-item list that Sarah has, but I do agree that obviously the goal of every government should be, how do we use our policy tools to stimulate economic growth? And we've been doing a lot of thinking about that with this new administration. The levers there at a macro level are energy policy. How do we lower energy prices for key technologies like AI? Fiscal policy, is the government overspending? Can we be spending less? I'm sure you've heard about our Doge that is stirring up things in DC. Taxation policy. And then the final one is deregulation. And that's something that we've been thinking hard about domestically, both at the DOJ as well as at the FTC. And our domestic project is around, as competition authorities, how do we identify anti-competitive regulations in the marketplace and bring them to the attention of the agencies that issued those regulations, those rules, and how do we either make those rules more narrow and focused on the good thing, not the anti-competitive thing, or how do we make those rules go away? And so that's a process that we have underway. And so I'm wondering if I can just, flip the script on the current mindset about sort of changing the process of competition enforcement, and then shifting it over to how can competition authorities play a role in deregulating the economy. So those are like the 3 big sort of items that I've taken away from my first ICN. Yeah.
Thank you so much, Gail. And I think that, they're really interesting. And that last point, I think, is a really interesting one. And it's I'm sure, a topic that we can and will come back to, because I do think there is a role. We've certainly been thinking about it in a UK context, how you can make sure that the right regulatory framework in different sectors is best set up to stimulate competition, stimulate growth. We had an example, actually more on the sort of consumer-facing side, where we had the infant formula market, the baby milk market, which was, motivated by very good public health reasons, but the regulatory framework was leading to really bad outcomes and really wasn't incentivizing competition. I think that is a really important role for us to play.
And you can see it across various economic sectors: transportation and healthcare, in the food sector, as you said. I think that's a key role we could play. That's quite different than how do we change our processes? How do we how do we speed up enforcement and so on, your 4 Ps, which are not without merit, but I think this is a really important role that I would encourage everyone to think about. I know it's already been a thing in the world for a while. I'm not the first to raise it, so.
No, that's great. Thank you. So can we dive a little bit, maybe, we'll come back to the digital side, but maybe on mergers first. Because I think, it's obviously a common theme. It's a global antitrust challenge for us all. How is the Trump administration thinking about merger review? How do you think the approach might change or be the same in the US going forward?
So thank you for the question. This is something that I've been seeking to clarify as much as I can once I'm given a microphone to speak into. So just to take a step back, we are the Trump administration, so that means we're not the Biden administration. This is so obvious, but I have to say it. It also means we're not the Bush administration. And so there was an expectation, I think, for us going into what is now his second term, that we would be more like the Bush administration. That was, I believe, an expectation within the bar. And of course, the president's not President Bush. He is very much his own person. And he won a very popular mandate, 7 swing states, the popular vote, and so on. And it was around sort of, America first, bringing ordinary working class Americans to the table again, giving them a seat when it comes to economic policy, and we are a piece of that. So to state the obvious, I can't miss an opportunity to do that. However, because we're not the Biden administration either, there were ways in which we were hearing a sense of frustration from deal makers themselves, as well as people representing them, that deals were not getting cleared quickly enough by the prior administration. And so we've been looking 2 months in at ways in which we can speed up that process. And we have already made some significant changes at the front end and the back end. And so at the front end, we have a process whereby we can grant what's called early termination to a merger review that's subject to the Hart-Scott-Rodino filing system. We have started doing that again. That hadn't been done for quite some time. And I think we're up to about 39 early terminations since March, so that's a significant change at the front end. At the back end of the merger review process, I was asked specifically at my confirmation hearing in February, and I gave a very specific answer about why the Biden administration had not taken settlements. The DOJ Antitrust Division, Jonathan Cantor, had been very clear in his tenure that they were not in the business of settling mergers. And there was, again, a sense of frustration with that. At my confirmation hearing, was asked a question about that, and I very clearly said we will be open to settlements. However, they must be robust with a strong bias for structural remedies, and so that's a significant change at the back end of where we are with merger reviews. And of course, I'm only 2 months in. Andrew Ferguson's a little bit ahead of me, but we are talking about ways in which we can do more on that front. So that's about your pace and predictability.
I was going to take the opportunity to draw the parallel.
Okay, there you go.
I think but that is exactly it. And we've had a theme, I think, through a lot of discussions over the last few days about that really targeted approach for antitrust, making sure that we absolutely identify whether there are issues, whether it's on the conduct side, whether it's on mergers, that we're able to take that action as quickly as possible, that we take action that's effective. To your point about remedies, I don't think any of us are in the market for soft remedies. We want remedies that properly address the concerns, but also that we are able to step out of the way and allow businesses to proceed with deals where they don't raise issues. And that's certainly a discussion we've been having a lot in the UK, and it sounds quite similar from what you're saying, I think, to that approach, which is it's always helpful to hear that commonality. I know everybody's going to be super interested to hear on the digital side, so let's get to the hot topic. Can you tell us a bit more about how, as you say, under the Trump administration, how's the DOJ thinking about your digital cases? You've already mentioned the search case. We've got the ad tech case. We've seen recent really important judgment there. Tell us a little bit more about those cases and more generally your approach to antitrust for digital cases.
Yep. So I'll start with an announcement that came out December 4th last year, which was the announcement from the president of his intention to nominate me to this job. And his focus was big tech. His focus was also, robust antitrust enforcement with fair rules of the road for everyone and so on. And obviously, even if that wasn't his focus, we at the DOJ have 2 very significant litigations that I inherited. One of them from the first Trump term. The search case was filed in 2020 and litigated and culminated in a liability decision last year. And then we have the ad tech case, which was filed by the Biden administration. It's both cases, I've said this to a couple of you, but for a broader audience, support very robust bipartisan support in the States. Right now, when you're looking at what we're doing transatlantically, it's like you might think that things are very partisan. Antitrust is not that. Just to give you some data points, I received 78 votes in the Senate. They obviously weren't all from Republicans. There are only 54 Republicans in the Senate, and so that was a good signal of bipartisan support. And then in the search case, we have 49 states who joined the case at the time it was filed, and the District of Columbia, where I live. So that case is now in the remedies phase, and you are all receiving MLEX and GCR, and you probably know more than I do because I'm doing a lot of other stuff about what's going on there. But long story short, the final day of the search remedies trial is today, and I gave you some of the details of sort of what a monumental task that was, and how steeped in evidence and fact and law the presentation of that case was on the DOJ side. The feedback from the team is they feel they gave it their best. They really did. And they fielded a lot of experts. They fielded a lot of fact witnesses, and they did some really, really solid cross-examinations of Google's witnesses. I've explained to some of you earlier, it's Google's preference is in their remedies proposal to sort of remove some of the exclusivity provisions in some ways in some of the contracts that currently cover search distribution. We're going a little bit further than that. The remedies proposals are all public knowledge, so I can speak to this. The focus of the DOJ's remedies at the highest level is the search marketplace has been frozen for 20 plus years in terms of competition and entry and so on. And how do we unfreeze that ice block? And key to all of that, of course, is scale and data. That's going to be something that will be very important for competition going forward. We've proposed divestiture of Chrome. There's been a lot of heated debate about that. The judge has seen a lot of evidence. I won't get into more than that. It's his decision at the end of the day. On both sides on that. But the principle behind it is this business of scale and data, and you all know, you're familiar with those issues too over here. On the ad tech side, we have an 80-year-old judge who is working in the Rocket Docket in Eastern District of Virginia, and she's a remarkable woman because she somehow managed, despite having her case filed significantly later than the search case, to catch up with the search team and the search judge. And so she has scheduled both DOJ and Google to appear before her for a remedies trial in September of this year. And so at some point, those two remedies phases might converge, particularly if this 80-year-old judge, Judge Brinkema, keeps up her pace. The issues there are obviously different. The decision is more recent. But we're proposing remedies that we think will remedy the harm of Google's monopolization, as the judge found, on the sell side of the platform, the ad tech platform, as well as the ad exchange itself. And so, again, scale, data, very important there. We have certain remedies that propose sort of fixing issues around that. We have behavioral remedies in our proposal too. And so that will all play out in September.
It's fascinating, and as you say, so much history building up to this point. It really does feel as though over the next couple of months we're hitting a really kind of critical moment in the resolution across both of those cases, and not just in a way that has an impact in the US, but as we were discussing in our heads of agency session yesterday, you know, I think the whole world and all of us as antitrust agencies are waiting and watching to see the outcomes in those cases. So fascinating to see how that develops, and we wish you all the best, I think, in that endeavour over the next few months. I know that you gave a speech recently, you mentioned this already, the America First antitrust. It would be really interesting, I think, just to hear a little bit about the principles that sort of sit beneath that approach.
Sure, and I'll try and wrap it up as quickly as I can for you. So because we are not Biden, not Bush, we are the Trump administration, we're looking at this sort of from a first principles standpoint in many ways. The first principle that I outlined in that speech, Sarah, was this business of, at the highest level, tyranny.com and tyranny.gov. Okay, so tyranny.gov is something that conservatives in the US have been concerned about for a long time. It was one of the animating factors for all Americans behind the revolution. I just mentioned the war and our separation from the mother country. And that was about tyranny.gov. However, it was also about tyranny.com. The Boston Tea Party was fought over the fact that the East India Tea Company had a monopoly over tea trade. And so it goes back to the roots of the country. The focus in recent decades has been mostly on tyranny.gov. However, there are an increasing number of conservatives who, for different reasons, have grown aware of the influence of what we call tyranny.com. And that's sort of the growth of monopolies and how both impinge on freedom, government intervention, interference, as well as the growth of monopolies. They're two sides of the same coin. And then we end with, an antitrust enforcement is a key backstop on free markets. And so that's our principle number one. Principle number two is conservatives in the jurists are very devoted to the idea that we follow precedent, textualism, originalism, go back to the enabling statutes, to the core congressional intent behind our enabling statutes. And when it comes to precedent, we're duty-bound to follow old and new precedent. And so that's something that has, I know, stirred things up somewhat in the bar. But we do have some old case law. We have some new case law too. We also have very important economic analytical tools that we use. We have, for the first time in a while, a deputy just focused on economics, Chetan Sangvi, who's also just recently started work, and so we're very focused on that too. But we bring that mindset to what we're doing. And then the last component of the speech, the last principle, was what we just talked about earlier, which is, we're not big proponents of regulation. However, we do recognize when you deregulate economy, actually that increases the need for antitrust enforcement, doesn't lower it. And so part of what we're looking to do, consistent with administration policy, is, as I said earlier, identify those regulations that we as antitrust enforcers can bring particular expertise to, identifying across sectors like transportation, healthcare, and so on, that have really their focus on creating entry barriers to smaller competitors, barriers to expansion for other competitors in the market. And so that work is underway with the Federal Trade Commission. We have a task force set up, and we're very keen to get to work there.
It's fascinating. I always find it so interesting and actually very inspiring, the way, I think, particularly in the US, you're able to really root antitrust in the sort of constitutional foundations. It is very strong. I think it's very empowering. And it's interesting listening to that, actually, because it kind of, you can do a bit of connection across when we're thinking about the ICN. And we think about, like, what are the foundational principles? We were talking a bit about this last night at the dinner. What were the founding principles that really drove the establishment of the ICN? The sort of themes in the context of the US around precedent, but actually for the ICN around consistency and commonality, and your last point around really, using antitrust as a tool to achieve that sort of greater good, those better market outcomes. I'm lifting and shifting a little bit, but it's quite nice to kind of think about how that works in an ICN context. And I know we're just about up for time. I would happily sit here all day
I would too.
and have this conversation. So I'm sure there'll be many more versions of it. But maybe just to close, if you don't mind, Gail, just with your sort of reflections back on that first question, and thinking about any words and thoughts you have for the delegates as we make our way back to our respective agencies, our respective jurisdictions. What would you sort of encourage in terms of that international community?
Please come visit with us. Please come up to me after, especially the young people here. You're here to learn. You are the future. I had the privilege last year of working in the Vance Senate office, and everybody there, I think I was probably old enough to be their mother, and some of them even call me mom to this day. You are very much the future, and I'd love to get to know you better. This network it's not a Gen X network. It's not even a Gen Y network, and let's bring in the Zoomers, and I like to end with that.
Thank you so much, Assistant Attorney General Gail Slater. We're delighted to have had you with us today. Thank you.
Thank you.
Welcome everyone to the final session of ICN 2025, the Advocacy Plenary session on competition in all policies, a balancing act. Before I begin, I would like to thank the ICN steering group and the working groups for such a wonderful agenda over the last couple of days. And I would like to thank especially the CMA, Sarah, Eleni, and the team for the fantastic organization at this conference. I'm actually quite surprised that we have got quite an audience this morning who managed to make it here despite the revelry and the dancing last night. But I'm quite sure that the panel that I have here before us today would be able to put up a good showing for everyone. So let's begin. Competition policy doesn't exist in isolation. As competition authorities, we often find ourselves navigating a complex landscape where competition principles intersect with various other policy objectives, be it industrial development, environmental sustainability, digital transformation, or tackling inflation. These are topics that we have talked about in the last 3 days. Today's session, Competition in All Policies, a Balancing Act, explores this intricate dance of priorities. We will today, in this final session, examine the challenges in effectively advocating for competition considerations into public policy making, while acknowledging the sometimes competing public policy goals. We will also explore advocacy tools and strategies to enhance the appeal of competition to policymakers and to effectively promote the inclusion of the competition lens into various policy domains. We have very distinguished panelists this morning. They are all senior members of their respective agencies and are well placed to speak about their agency's experience in navigating policy making. We have Ms. Michelle Cohen, the Director General of the Israeli Competition Authority. Michelle joined the Israeli Competition Authority in 2006 as the Deputy Legal Advisor, Criminal Affairs, before being appointed as the ICA's legal advisor in 2018. She was appointed as Director General of the ICA in 2022. Next, we have Michael Agonado, who was appointed the Chairperson of the Philippines Competition Commission in 2023. Michael worked as a lawyer in private practice for 17 years before joining the public sector. Just prior to his appointment at the PCC, he was Chairperson of the Commission on Audit and concurrently external auditor for the World Health Organization, Food and Agriculture Organization, the International Labour Organization, and the UN Industrial Development Organization. I don't know when he finds time to sleep, actually. And thirdly, we have Mr. Benoit Carr, who was appointed the President of the French Competition Authority in 2022, and is also the Chairperson of the OECD Competition Committee. Benoit was Chief Economist at the Directorate General of the Treasury before being appointed as a member of the Executive Board and Governing Council of the European Central Bank, and subsequently head of the Innovation Division at the Bank of International Settlements. And finally, we have Dr. Mahmoud Montes, who was appointed Chairman of the Egyptian Competition Authority, and he also serves as Commissioner and Chair of Committees at the COMISA. He also leads the African Heads of Competition Authorities Dialogue. And Mahmoud was previously a private sector development specialist at the World Bank and also the first president of the Arab Competition Network. And I know this year is also the ECA's 20th birthday, the same as the Singapore Competition Commission. And I wish you, the ECA, a happy birthday this year. Now let us begin by discussing some of the success stories from our panelists. Michael. Oh, sorry, Michelle. Michael. Yeah. Michael, can you share an example where competition considerations were successfully balanced with other policy priorities in the Philippines?
In Israel, maybe.
Sorry, we'll start off with Michael first.
Michael.
Yeah.
Sorry.
Okay, hi, good morning, everyone. Yes, although we're a young competition agency, we've been fortunate enough to have a national competition policy since 2021. And so in a general sense, that's, put the national government on notice that, hey, you have to consider competition issues when you draft your regulations, when you consider bidding and so forth. And so in a general sense, it's helped us a lot because you do have that policy and they're supposed to abide by it. And 2 years ago, they made their performance bonuses dependent also on adherence to competition policy. So as far as the government's concerned, they're very much aware of us. And so when they do craft policies, they have to consider the competition lens as well. And so they consult us consistently. Our legislators consult us as well on laws. And it's in some of these proceedings and deliberations that we get to participate. And inevitably, some of these laws will have certain aspects that might be anti-competitive to some extent. It might create certain barriers to entry. For example, if you want to promote the growth of a certain industry in the country, then obviously you're going to be granting certain preferences to them. And naturally, if that is really the road that they want to go, and which is mainly to spur economic growth, well, you have to adhere to that as well. But what we do tell them is, okay, this is fine, except that it should be time-bound. You know, it shouldn't be something that continues for, in perpetuity. It should be something that has a specific time frame. Because otherwise, you'll never be able to remove it. Because it would take legislation to remove it, and it's difficult to actually get that done. So we've been fortunate enough that we have a Congress that kind of listens to us for the most part. And so when there's a balancing there, we also understand their considerations, what they're trying to achieve, and we try and work with them in order to get that. So we're not too much sticklers for competition. We try and balance it as well. On the case side, we did have a recent transaction involving 3 of our major power generator players. They decided to band together to put up a LNG terminal and facility for natural gas. No? And one of the parties was also the major distributor of electricity. And so while cross-ownership is allowed up to a certain percent of generated capacity, it certainly raised issues of coordinated effects. And it was very complex, and there were a lot of concerns. However, at the end of the day, when we allowed the transaction to push through, you might say the biggest consideration was the need for that investment. It was a $3.3 billion investment. The Philippines has one of the highest energy rates in Asia. It's, I think, the highest energy rate in ASEAN. And so it's a big concern for us. And so we said, okay, it can proceed subject to certain commitments. There will be a lot of monitoring involved, of course, something that we're not fond of doing, but in this case we had to. But the other consideration as well is that it's a regulated sector. So, there's an energy regulatory board that oversees them, and we have a Department of Energy that looks over the policy. But again, we did mention in the decision that this cannot be the job of one agency alone. So we have to work with both the Energy Regulatory Commission and the Department of Energy. And in fact, when I get back, it's the first thing on my plate. I have a meeting with both agencies to discuss how we move forward on that. But I'll just leave that as some examples. Thank you.
Thanks, Michael. It's great to hear that Philippines has tied competition policy so closely with its national development goals. And to people's performance bonuses, I think that's really food for thought. So, Mahmoud, let's hear about Egypt's success stories.
No, thank you, Alvin. Thank you for being here. So, actually, in 2021, we put together a full strategy, a 5-year strategy that takes into account several matters, but the one that I want to emphasize on is the second goal that we set, which is limiting anti-competitive governmental decisions. And here we developed what we call kind of a whole government approach. We said competition agency, yes, do have a role to play, but the whole government has a role to play in competition policy. And from that perspective, we developed we do have in our law that have been passed, amended in 2014, that we give opinion to government entities, and government entities should consult us before putting in a legislation or a decree that has to do with competition. But the problem was it was a mere opinion. So how to change this mere opinion to more of a binding kind of way? So here we developed what we call the Higher Committee for Competitive Neutrality and Competition Policy, headed by His Excellency Prime Minister and a number of ministries. And the Competition Agency is the technical office of the committee and the rapporteur there. And there we developed a department within our agency where we receive complaints from investors saying, we do have a problem with this decree that's hindering our entry, or there is a discrimination, or so on and so forth. And from that perspective, we started working with various competition agencies, and we developed guidelines for governmental agencies to look into before issuing new legislation, which is a competitive neutrality guidelines. And with these guidelines, we prevent new legislation to come on board. And currently we're working on something that I hope it would see the light soon, which is a more of an AI thing that government agencies can put in draft legislation. It pinpoints where the problems are, and in phase 2, hopefully it could give an idea what alternative solutions would be. So the committee here would resolve existing problems. The guidelines would resolve or prevent new legislation that affects negatively competition in that regard. And that all have been put together also within the ownership policy, which is a document that says where the government is going to invest, and if they're going to invest in this direction, there is a full chapter, which is chapter 7, that talks about competitive neutrality and how SOEs should behave. And also we issued with the Ministry of Justice a new law that actually eliminates any discrimination in taxes presented to SOEs. So this is like a highlight of how we try to incorporate government with the competition agency and other agencies to make sure that competition is at the heart of the governmental decisions. Thank you.
I think those are great examples from Egypt, and I strongly support the whole of government approach in injecting competition principles into government policies. Let me turn now to Israel. Have there been areas or sectors where it has been challenging to align policy with competition principles, and how did the ICA deal with these tensions?
Okay, so since introducing competition consideration can often come into conflict with other regulatory goals, we constantly facing trade-offs like what do we compromise on and what do we insist upon. And I want to share a particularly challenging case study. A little over a year ago, an interministerial committee was formed to review growing trend in Israel of insurance companies acquiring many small insurance agencies. And the committee included representatives from the Ministry of Finance, the Capital Market Authority, and the Competition Authority, and was formed to assess this trend. And given the characteristics of this sector, the Competition Authority identified several competitive concerns. I will focus on one of them, that insurance products, especially pension and saving plans, are complex products. Most consumers have a hard time comparing them or even understanding what suits their needs. So when people buy insurance independently, they're often not in a position to make a fully informed decisions. So from a competition perspective, insurance agents play a vital role. They help bridge the information gap, they explain the options, they compare prices and quality, and when they do their job properly, they drive competition. And they make insurers work harder to offer value to consumers. But doing so requires that the agent's interest are aligned with those of the consumers. So when agents are owned by insurers, that alignment breaks down. And the Competition Authority advocated for structural change to address this market dynamic, but the Capital Market Authority strongly opposed such changes. And their reasoning was centered on regulatory efficiency, because insurance companies are large, well organized, few in numbers, and they're easy to supervise, while the insurance agencies pose greater regulatory challenges. So we reached kind of a dead end in this committee, and at that point we had two options as a competition authority. We could publish a minority opinion, which is each authority stating its own position, or disband without offering any real recommendation. But then we found a breakthrough. Like during the discussion, we realized that despite disagreeing over the issue of insurance ownership of agencies, all members agreed with our analysis of market player incentives. Specifically, they accepted our assessment that insurance agents, including independent ones, are truly not objective consultants. That's because they are paid by the insurance companies through commission based on the premiums their clients pay. So this creates a market where insurers are competing to attract agents, not end consumers. And based on this shared understanding, we propose an alternative to change the model so that agents will be paid directly by consumers. And that way, we think that agents would have to justify their value directly to the person they're supposed to serve. So we think that this agreed solution can play a role in deriving competition to this market. Now, every solution has trade-off. This solution has also some trade-off. But the point I want to make is that despite the big disagreement on one issue, we found common ground on another, and that gave us a way forward. So, of course, the road ahead won't be easy, and lobbying groups are waiting on the side of the road, but the agreement among the relevant regulator and ministries carried substantial weight in advancing competition policy. And this experience actually taught us the value of flexibility in our goals, which start off focused on one issue, but then when this path hit resistance, we used the disagreement itself to find consensus on related important issue. So this kind of work doesn't always lead to success, but I think when I look at the advocacy work of the authority over the year, I can say that the way to promote competition, especially in complex environments, is to compromise, like just in any other negotiation. Thank you.
Thank you. I think I totally agree with you that you may not always get success, but I think when you work together with other regulators and when you achieve that breakthrough, I think it's very satisfying.
Yes.
I think we all agree that financial markets in particular are a very tricky area to deal with, and my congratulations to the ICA for its efforts. I know Benoit has spent many years of your life in the financial sector, and how have you brought that years of experience to your work now in the French Competition Authority?
Thank you, Alvin, and good morning, everyone. Before diving into the specifics, I would like to say that bringing on stage this discussion on the interplay between competition enforcement and other policies is really very important, and I guess we can all relate to what each other has said. We share the same experiences, and there are different reasons why this discussion is so important for us. There is a fundamental reason, which is that if we want to be good enforcers, we need to be independent. Independence is really of the essence, because we are addressing powerful corporate interests, and and by definition, we are after the most powerful of these interests, and so we need to be independent. But in our democracies, if you're independent, you need to be accountable and mindful of the broader priorities of society. And if you're not going to remain independent for very long. So it's in a way a condition for us to survive and for our policies to be sustainable, and that can play out in different ways. And I would say both in a defensive way and in a proactive way. In a defensive way, when we enforce competition law, we have to navigate a very dense thicket of regulations, probably denser in Europe than anywhere else in the world, and maybe even more in France. And so we've got to understand these regulations. We've got to understand the kind of trade-offs it entails for us. Some of these regulations can be good for competition. Some of them will be bad for competition, and we need to make sense of it. And in a proactive way. And here I would support very much what Gail has said earlier on this stage. We need to use our advocacy powers to identify regulations which are bad for competition and therefore bad for jobs and growth and innovation. And we've been doing it a lot in France, and we've been very unpopular with some of our market studies. Most recently, we issued a market study an opinion on the unregulated electricity prices in France, and we've been hugely unpopular. But we had to speak up and explain the consequences. So it's a crucial discussion. The example I wanted to give actually does not come from finance, but more it's on the privacy side because it relates to our latest decision. So it's very fresh. It comes fresh from the oven. It relates to our latest decision against Apple on their app transparency framework, and that's about the way Apple enforces privacy regulation on the App Store and the way consent is being sought from the user on the App Store. And the way consent is being sought in different ways, depending on whether the app is an Apple app, is a proprietary app, or a third-party app. And you can see where competition comes in. It's an interesting story because it didn't start very well. And I think it ended up in a much better, well, it's never the end of the story, of course, but we are now in a much better place when it comes to understanding and kind of optimizing the relationship between privacy regulation and antitrust. And as we know, I mean, privacy should be a competition parameter. So in the first instance, there should be no contradiction between privacy enforcement and competition enforcement. I mean, consumers should be able to choose whichever service is better for their privacy, better protects their data. But we also know that, in practice, it doesn't always work like this. You have the privacy paradox, which we know very well, that users don't always make full use of this possible choice. And also we know that big players can abuse privacy regulation to raise barriers to entry. And so there is a trade-off there. And so the way we've dealt with that is by building a relationship with our data privacy regulator, like CNIL, along a number of steps. So it's really a journey that we've taken together. We've issued a common statement on the interplay between competition enforcement and privacy enforcement back in December 2023 with a joint conference with academics. Last year we've issued an opinion at the request of the Privacy Authority on privacy enforcement in app stores generally, where we very much focused on the way dominant players could use and maybe abuse of privacy regulation to raise barriers to entry. So there are all kinds of legal considerations, but the plain English version is that you don't want the hen house to be guarded by the fox. I think that's the plain English version of a 100-page opinion. And so we told our privacy colleagues that really they shouldn't trust dominant platforms to enforce GDPR according to their own terms, because that could create severe competition concerns. And then we have this Apple decision where basically we said that the way Apple had enforced GDPR was neither fair nor proportionate, and wasn't needed, and that the way they had enforced GDPR had been unfair to third-party app providers, and that Apple, by doing so, had abused their dominance, and we had a fine of 150 million euros, which is not very much when you think about it, because it's when we're talking about Apple. And we could build on an opinion provided to us by the privacy regulators. Privacy regulator also making the point that the way Apple had enforced GDPR was neither needed nor proportionate. And so the bottom line here is we pursue different objectives, different goals, but we believe that we have a duty to, when we enforce competition law, to minimize privacy issues, and they believe they have a duty when they enforce privacy regulation to minimize competition risks. And hopefully, in most cases, we'll meet somewhere in the middle. So, of course, any economist in the room will say, okay, that's a Nash equilibrium, so it's unstable. Yes, that's true. So we've got to make sure that it remains stable, and it's hard work. But at least we know that we can meet in the middle, and in that case, we've actually met in the middle. So that's really a positive story.
Thank you so much, Benoit, for that roundup on the relationship with the privacy regulator in France. I think back home in Singapore, we also have been working very hard with other regulators as well. We've also built a relationship with the privacy regulator. We've done market studies before, and I think we have got quite a decent symbiotic relationship with them. So hopefully that's a little bit more stable as well. So just to add that in Singapore, at the CCCS, we also regularly receive requests for advice on competition matters from other government agencies, and we've painstakingly built that credibility and trust over many years. And for instance, we also regularly organize a forum for a community of practice for competition practitioners for other economies within the government sector, and some of whom have to regulate competition issues in other sectors like the financial services sector, the energy sector, or the telecom sector as well. I would like to ask my panelists today, in your experience, what advocacy tools and strategies has your agency used to promote competition considerations in other policy domains? And how do you build that trust with other domestic regulators? So perhaps we could start with the ICA's example.
So I can say from our perspective that the journey of the Israel Competition Authority to become a trusted advisor to the Israeli government ministries didn't happen overnight. In fact, our authority wasn't always particularly active in advocacy work, and this process evolved over I think the past 10 years or so. So I will start with some background. Like back in 2011, Israel experienced widespread social protest against the rising cost of living. And this marked the first significant public outcry focused on specifically on the cost of living in all sectors in Israel. And in response, the government set up a committee tasked with proposing solutions, and the Competition Authority participate actively. And one key recommendation from this committee gave our authority the explicit power to examine competition in various economic sectors, identify barriers to competition, and submit a recommendation to the government. And as we started to publish unbiased, data-driven researches, other authorities and regulators began recognize and respect the ICA capabilities, and our economic and empirical capabilities improve as they improved. Our reputation and as a professional authority grew accordingly. So ministries increasingly invited us to discussion when competition issues arose and recognized our unique expertise and reliable insights. And I must admit that building strong empirical capabilities took time. We've produced both sophisticated, economically in-depth research and simpler studies as well. But our ability to bring database conclusion to the table has been tremendously significant. In fact, the Competition Authority is the only body in Israel with such a broad access to real market data in all market sectors. But advocacy for competition is not straightforward. Despite wide acknowledgement of the competition's benefits, various competing interests often arise. Agricultural lobbies protect farmers. Domestic industries resist imports. Banking authorities stress system stability. So tension naturally develop between these various interests and our advocacy for competitive markets. So we adopted some strategies. First, professionalism and robust data-driven research became our foundation, particularly when faced with populist arguments or agenda-driven positions, but this alone was insufficient. Realizing this, we decided to build a strong, ongoing relationship with relevant government ministries and agencies. So in 2018, in order to enhance our ability to promote competition, we established a special department focused in advocacy work. And we have dedicated teams structured by market sector, food and agriculture, finance and insurance, transportation, communication, and energy. And each sector team consists of both economists and lawyers who handle mergers and advocacy tasks. And another impactful initiative we launched is our Promoting Competition program. We targeting senior government officers across ministries. It's a 6 to 8 month program where participants meet monthly to learn competition principles and practical applications for their respective areas. So each program cycle hosts up to 15 officials, and we carefully structure the program to respect the participant busy schedule. So we're providing them meaningful contact without overwhelming them. Participants engage in real-world examples, case studies, and lectures, and each program cycle culminates in a valuable learning visit at the OECD, where participants interact directly with international competition experts. So this program has been particularly successful in deepening ministry officials' understanding of competition policy. And beyond education, the relationships built during this program have been invaluable. These days, we are preparing to launch the third cycle of this program. And I think, in short, if you ask me how to effectively build trust and credibility and successfully advocate for competition, I say it boils down into two essential ingredients. First is the robust data-driven knowledge, and the other one is the strong interpersonal relationships. Thank you.
Thank you. Those are great tips, and I think that it's definitely food for thought. Benoit, what tips might you have for the rest of us?
Well, I guess we have to be flexible and be able to pick different tools in our toolbox. So there are different ways for us to do it. We need some element of formality in the way we interact with regulators and other policymakers. For instance, in France, by law, we can be consulted by sectoral regulators, and of course by the government and by parliament on the competition consequences of their plans, and vice versa. We can seek advice, as as I said earlier, for instance, from the privacy regulator or the telecom regulator or the media regulator, particularly on merger project, but also in antitrust. So that's all foreseen by French law, and I believe we now have a clear direction set by the European Court of Justice when it comes to the collaboration between competition authorities and other authorities, particularly in the Meta Cartel Amt decision and in the B-Post decision. So it's all, it's kind of. I'm not saying it's very detailed what the Court of Justice tells us, but at least the direction is clear that there is a duty of cooperation across regulatory domains. That's one thing. Then we've been using market studies, market investigation a lot to highlight competition issues in some areas. So just to give one particular example in the area of transports, recently we released a very far-reaching and broad study on land transport, including rail, high-speed rail, local rail, coaches, taxis, and Uber, and so on, where we've reviewed. So there is an element of self-evaluation. We've reviewed all our own recommendations over the last 10 years and to see whether our advice had been followed or not by the government and parliament. And we've passed a number of new messages when it comes to competition in railways, competition in the way public tenders are being organized for local transport, and so on. I think that had some impact in France, and also we issued separately a market study on electric vehicles charging docks, like many of us have done, including considerations also on the way docks are being tendered by or sub-tendered even by highway operators and so on. So with very practical recommendations, and that also did have an impact. And maybe one last example of still a different instrument is on the electricity market. There is a big transition going on in France from a very regulated, very heavy regulation of electricity prices, including a duty for the monopoly producer of nuclear electricity to resell its nuclear electricity at a given price, at a subsidized price, which is an enormous state aid, which had been cleared by the European Commission, of course, but it's an enormous state aid. And the government's plan is to move towards a more market-led system, which on the face of it sounds good, by letting the electricity operator EDF pass contracts with different industry participants with a market price. So basically, that all sounds very good, but of course, when you move to regulated prices to market prices, and when you have a monopoly, because we're talking of nuclear electricity here, and it is a monopoly in France, of course, the risks move from state aid to abuse of dominance. And so we told the government, look, that's a good direction to take, but of course you will need safeguards against possible abuse of dominance by the monopoly operator. And in order to be heard, we actually partnered with the energy regulator, and I wrote a common letter with the chairperson of the electricity regulator to the French government, highlighting a number of risks that we could see moving down this new road, and the fact that the initiative was common between the competition authority and the electricity regulator had a huge impact, in fact. So that said, that was more than 15 months ago, and I still don't have the answer. Well, it just kind of shows that it's a complex issue, but the messages have been passed, and so that shows also that we on specific issues you need a tailored answer, and you need to be able to step in the discussion at the right point in time. Maybe one last remark, if you allow me, Alvin, is about the importance of international cooperation. I mean, as we can see this morning on this stage, I mean, we have a lot to learn from each other, and here one interaction which I think needs to be optimized and maximized is between this group, the ICN and the OECD. The ICN has a tradition to reach out to other policymakers, as we've seen, for instance, in the steering group statements during the energy crisis and during the COVID crisis. The OECD on its side has an extraordinary wealth of expertise and knowledge in different sectoral departments that the competition committee can tap, and also a tradition to reach out to business and to trade unions. And so we've done a lot together, but we really need to kind of strengthen the interactions and collude in a positive way.
Thank you very much, Benoit. I mean, from my own personal experience, I think it's terribly important to sometimes get into the shoes of the other regulator, to know what pressures they are facing as well, to know what constraints they are facing, and what is the ultimate mission that they have to try and achieve. And I think the other side typically would be very appreciative of what you're trying to do, and they would also reciprocate by extending that trust to you and to be able to try and work together with you. And I think that usually works for much better win-win outcomes. We now move eastwards to the Philippines, and Michael, can you talk through with us about some of the PCC's initiatives to foster stronger advocacy work in your country?
Okay, our competition law was only passed in 2015. We're kind of late in the game. The commission itself was set up in 2016, so we're on our 9th year. We're just 1 year younger than our Hong Kong folks over there who just celebrated their 10th year. Shout out to you. And so if you talk about the culture of competition, we've never really had one in the sense of competition law and economics. When you say competition in the Philippines, sports, that's what they think of. So I think we've learned that, if trying to raise public awareness, through, social media and the like, no one goes to Instagram to look at, competition issues. No one goes to Facebook really just for that, So I think the key point, and I take this off as well from our colleagues here, is the need for engagement with these government agencies and other policymakers. And so our focus over the past 2 years has been engaging with them. Of course, the whole of government approach is very important, and you know that government agencies typically like to act in silos, and very jealous about their turf. And so you have to break through that barrier. You do execute memorandums of agreement, but those are just paper accomplishments. The more important thing is, are you actually implementing it? Do you do that? And that's where we've focused some of our efforts. So when we do market studies, before these actually get published, we actually have sessions with the agencies involved. So we can also get input from them and some feedback. And so I think that kind of engagement has helped us establish credibility with these agencies. That, we just didn't get the data, come up with conclusions, and this is it. But we give them a voice, we get them to look at it. And a lot of them have been appreciative because sometimes it actually supports some of their contentions. And sometimes when they go for Congress and ask for additional budget for certain programs, they're able to rely on what we provide. And so I think that establishes some degree of credibility. We have a bit more problem with sector regulators. I think for obvious reasons, I suppose everyone has had that kind of a problem. But, we're reaching out. And part of it, as mentioned by my colleague here, is the interpersonal relationships. I think that really goes a long way. If they see that, okay, he seems to be a reasonable fellow to speak with, But at the same time, it's not being too nice because they might also think, I can push him over. It's no problem. But I think that's very important. So it's a combination of those things, They meet with you and they realize, okay, this is a person who's okay to deal with. He's a stand-up guy. That's fine. But at the same time, they can see your intentions in reaching out to them. You're not trying to steal their thunder or their power because you can't anyway. And they see you're just trying to do your job, but you're involving them. Again, a whole of government approach. And so that, so far for us, has been quite effective. And so we've tried to branch out from that as well. Now we're involving some of the local government units, because we do have cases that are, you might call de minimis. And so you figure, are these matters that should really go up to the commission, For example, price fixing by water refilling stations, which, operate, these are basically mom and pop shops, And so we're trying to involve local government so they can also educate some of these businesses that fall within their purview. We've also engaged with chambers of commerce. And our communications guys established what they call Champions of Competition. So it's sort of a program that involves big business. And a lot of them, surprisingly, were very appreciative. And in fact, we were able to help some of the brick and mortar operations, because they've been complaining for years that, look, we pay value-added tax. But if it's sold online, there's none. And our costs are much higher because we maintain, stores in malls and standalone shops. So they asked us, help us in pushing for, taxation of internet transactions, which eventually they got last year. So we engage with all of them. We also engage with practitioners, such as you were mentioning, community of practice. I think that's important as well, so that they understand a bit of where you're coming from. I mean, big business, they look at us, as suddenly a hump in the road. There was no hump there before, and now there is one, and it delays, transactions, even though we do have strict timelines and mergers and the like to ensure that, things don't get delayed more, unreasonably. But again, it's all about engagement, both talking with them, but also in your actions. It's not just words, but action, right? Okay, thank you.
Thank you very much, Michael. My key takeaway from you is that competition authorities need to demonstrate value. You must be able to work through matters in a very timely manner, so that you are not that long hanging hump in the road that, they send a request to you and it takes forever to get back to them. And by which time I think the deal might have already lost its value proposition. So I think that's very important, and I think that goes back to Sarah's point about pace as well. I think I might also borrow that. And lastly, on the point of personal relationships, I think to go through the process with a team that is understanding, able to, is pleasant to deal with, rather than very officious. I think that totally wraps up the relationship, and I think that would encourage a lot more trust and understanding from other regulators. So last but not least, to champion the cause of competition in Egypt. Mahmoud, can I have your views as well?
No, thank you. I think it has been said all. I mean, it's trust, personal relationships. I think these are the bottom lines. But let me share some of the ideas that we started with, and how actually some of the regulators helped us through our work. And to give you an example, so let me start with first, in the Prime Minister's office, currently there's no any new regulation that goes to cabinet before it passes through the competition agency to give an opinion on the competition angle of it. So that was a perfect breakthrough for us. Second was the Ministry of Health. So we just amended our law to have a suspensory pre-merger notification regime 8 months ago. But before that, we worked very closely with the Ministry of Health, because we thought that there is a problem in the healthcare sector when it comes to merger and acquisitions. And for around 2 years before the pre-merger notification approval, any transactions in the healthcare that the ministry receives, it sends it to us to give an opinion on it to them before they approve it. So that was also another thing that pushed the government as a whole to have a pre-merger notification regime as quickly as possible. Another thing with the Ministry of Education, so we had a number of matters in the school uniform and bid rigging in the publishing or printing of school books that the ministry provides every year. So there with the Ministry of Education, we worked very closely. We issued guidelines on school uniforms that nobody should be tying to buy their school uniform from certain shops or certain areas. And that was also produced in a decree by the Minister of Education that also aligns with the guidelines. He even mentioned the guidelines in the decree, which is, for us, it's also a big step through that there is a support from the government, support from the ministry. They do understand the work, they do understand the benefits. And to be very frank, also, understanding the benefit comes with concrete and economic results. And that's also what helped us through all our interaction in advocacy. I would say providing decision makers with concrete evidence, concrete economic results of such matters really makes a huge difference. And that even led with the Ministry of Education that we started embedding competition principles within primary education. And this also helped us that we believe that within maybe 20, 30 years, we develop what we call now in our strategy competition culture. So competition culture in our strategy stems from academia, which is, for me, it's the most important part. And currently we do have this with the Ministry of Education. We also do have this with the Ministry of Higher Education to embed it within universities. And currently also we're pushing through this agenda with judges and the judiciary as a whole. And this was also another important matter that the public prosecutor, because we do have a criminal system, but it's a criminal fine, put that competition cases are a priority to the prosecution office. And also, given that the most of the importance lies within government, so we do have very good relation, for example, with the procurement agency, which also we signed a joint guidelines for public procurers on how to detect and view bid rigging cases, which led them to amend their law, and within their law said if there is a competition infringement or a bid rigging case, this bidder would be prohibited to enter any bid, which is something that rarely happens, that they do embed competition in their own law as a result of their infringement. So I think, again, this was all built through trust. It took time. And I think there is a lot of lessons learned. Of course, I'm talking now of the success stories. There are failures, definitely. And but as a whole, I think it's worth doing it. Thank you.
Thank you very much, Mahmoud, for sharing on the competition culture in Egypt. And thank you to all my panelists for the very insightful sharing. We have heard about great stories about the competition advocacy efforts ranging from financial markets to school uniforms to energy and transport. And competition principles are pervasive in all aspects of the economy. And we should remember that the work that we all do is fundamentally beneficial to our citizens. And as we return to our jurisdictions, I think we should all allow that to bask over us as we go to bed tonight and to feel good about the work that we do. And please give my panelists a warm round of applause. Thank you.
The good news is this is the last panel you have to sit through this week. Of course, the bad news is this is our last panel together this week. My name is Paul. I'm from the FTC, and I am overjoyed to be joined. Well, I'm going to keep you as a special guest here. Eduardo from Paraguay. I have Kaylee from Canada, and I'm joined by my friend Graham from Sweden. As I said, we've got a special guest. We'll get to him later on. I'd like to build a little anticipation for that. We welcome you all to the Implementation Panel. We all know that the ICN is an informal, voluntary, non-binding network. It's sort of, we've memorized that phrase, right? Member agencies choose to use the ICN and its work product in ways that are relevant to their own needs. So the why then, Paul? Why do we care about implementation? I know you're asking. Well, ICN Icon and ICN Chair Andreas Mund identified implementation just earlier this week as a pillar of the network, saying that if we want to ensure that the ICN and its work products matter, we need to promote their implementation. Implementation in the ICN refers to efforts to promote ICN work and offer support to members that are interested in learning more for their own consideration when establishing new rules, tools, or practices. Indeed, this panel asks one of the most difficult questions in ICN. How does your agency use the ICN? This is a hard question not because there are no answers. It's a hard question because there are so many ways in which our members, and even NGAs you'll hear, use ICN work product. Today our panelists will share stories of active participation in the ICN and the use of ICN resources. Very grateful for their time and willingness to share and inspire us all. As is tradition, our panel also serves as a tribute to our hosts in the host location here in Scotland. The panel planning team carefully considered the wisdom of Scottish proverbs and was inspired to use them to help convey our message. At the very beginning, we learned, old saws speak sooth. Old proverbs speak the truth. I thought, what a perfect start for our research. We're onto something. Indeed, this is going to be pretty easy. So I thought, well, let's just test this out. What's a famous proverb in English that I know? Okay, if at first you don't succeed, try again, right? So I looked up the equivalent in Scotland. Early crook the tree that guide crummock wad be. All right, oops, maybe this is not going to be as easy as I thought it would be. This is not the English I know. Let's try another one. Well, what about, there's no time like the present. Well, here it's the thing that's doing is no tay day. All right. I thought, was I as useless as a chocolate teapot? I realized we're going to need some help. So luckily, just the right proverb spoke to us.
Ne'er let your feet run faster nor your shoon.
Ah, in other words, don't outstrip your resources. We realize there's always an expert. There's always someone to learn from in the ICN. And indeed, when we needed a Scottish expert, of course, we called Stockholm, right? And Graham Jarvie, one of the nicest, kindest, most gracious ICNers you'll ever find, agreed to help me not embarrass myself. Indeed, his first advice to me was,
Caw canny, but caw a wa.
Go carefully, but keep going.
But Paul, also make sure your bum's not out the windy.
That means talking absolute nonsense, apparently. So, with that pep talk, we were determined to keep the heat, keep calm, and get laddie.
Get laldy.
Okay. In other words, do our best. All right, the mission of the ICN recognizes the real-world impact of our work. Now, these week's discussions, they're wonderful, and I hope you've gotten a lot out of them. But what you take home and what you share the rest of the year is equally important to the network. So let's turn to the core of the ICN experience now and hear stories from our panelists on how they use the ICN. Eduardo, the head of the Paraguayan Competition Commission. Tell us how your agency views and values the ICN.
Well, first one, hi everybody. Thank you, Paul, for inviting me to this closed panel. So this is our third ICN Congress, Our first one was in Barcelona, 2023, then Brazil, and well, here in Edinburgh. Well, I think the ICN annual conference was not just a global event. It was a learning experience, really, that will shape my contribution to our competition authority. I think the mix of formal knowledge and informal exchange reinforce that effective competition enforcement depends as much on sound policy as does it human connection and shared purpose. So, in the formal aspect, I have new ideas. I learn about how many countries take different positions in the same problems we have in Paraguay. I think how they explore data-driven cartel detection tools and how can competition agencies and sector regulatory can work together. I see how in some countries they use MOUs or formal agreements, and in other countries they use another kind of tools. But I think I really return for new tools for our agency, new ideas, new fresh ideas about competition and how can be more effective in that. The most important, I return with new friends and new allies in competition world.
Wonderful. Thank you, Eduardo. I know some of you are thinking, I think I see a yellow lanyard up there. What's an NGA doing on this panel? But yes, NGAs, as we all know, are a vital part of the network, and indeed they take value from ICN as well. And Kaylee's got a particularly creative story that we'd like to hear from.
Thanks, Paul, and hello, everyone. So I am a new NGA, so my, I guess, formal participation in the ICN is relatively new, but I first became aware of the ICN when I started practicing about nearly 20 years ago, so it was in, I guess, the beginning days. Internally at our firm, we would use ICN materials, particularly pre-merger notification threshold templates to help assess merger review requirements for global mergers that we were involved in. So that was, I think, my first introduction to the materials, and have consulted them here and there over the years as I've kind of continued on with my practice. And in the last few years, I have been coaching a university moot team. The Competition Bureau about 7 or 8 years ago in Canada put together this wonderful competition law moot for Canadian law schools to participate in to help further expose law students to the practice of competition law and policy and generate interest in the area. And prior to engaging in a coaching capacity, I was involved as a judge and really enjoyed the program. It's one of my favorite ways to engage with the Bureau and the bar on an annual basis. But anyways, as a coach, I help the students, particularly the school that I coach. They don't have a competition law class at their law school, and so I, in addition to them, reading Bureau materials and obviously the legislation and case law, I provide suggestions of international resources that they may want to review because it can help them understand some kind of core principles, foundations for competition law policy. And so one of the resources that I suggest that they consult is the ICN website, taking a look at the materials that are available, whether the moot problem of the year is an abuse of dominance problem or a mergers problem or something else. But that's a way that I think or I understand, is a unique use of the website, even by individuals who don't practice or have a professional connection to competition law or the ICN. So that is my innovative way of using the ICN materials. Thank you.
That's wonderful. Thank you, Kaylee. Not only did you give us an example of the incredible reach of ICN work product, you managed to disprove a Scottish proverb, so thank you. Ye canna pit a young heed on old shoulders. It's impossible to give the young the wisdom of the old. Not in the ICN, apparently. All right, let me now turn to not only my favorite Swedish Scot, or is it my favorite Scottish Swede, my crutch today, but he's also got a story for us. So Graham, tell us about how your agency values the ICN.
Yeah, thanks very much. I'll try and avoid using too much Scots or Glaswegian when I'm making my remarks. When I thought about ICN implementation, the new operational framework of the ICN came to mind. We heard about that earlier this week. This is something that's hopefully going to make leadership roles and various roles within the ICN open to new and younger agencies. There are going to be new opportunities to engage with the ICN in different ways. And in Sweden, we've been fortunate enough to be co-chair or project lead in various working groups over the years. And what we found is that the time and resources that we put into the ICN, we reap those benefits by getting something out of the ICN. It helps us get closer to the ICN work. In the projects that we've worked on, we've really got a deeper understanding of the international perspectives on a whole range of issues, whether that's market studies or agency effectiveness through digitalization, or now exclusive dealing and unilateral conduct. So with those opportunities that are available for agencies to get involved, I would really encourage it if you have the interest and the opportunity. But even if you are not ready or able to take on those leadership roles or co-chair roles and so on, I think there's so much to get out of the ICN. And I come away from this conference, as I always do, with a few of those light bulb moments where you've been in a breakout session or listened to a panel and you think, well, that's something I want to take home, and that's something I want to spread to my colleagues. And I'm sure that's the same for everyone here. But the ICN doesn't stop and start at the annual conference. We've got webinars throughout the year. We've got the written work products. We've got workshops. So those light bulb moments are things that you can kind of continuously get from the ICN engagement. And just a final thought about implementation within our agency. Some of you may be aware that there's a vast wealth of video modules, training on demand, which is something that we make available to new staff. That's fantastic training modules with experts speaking about the range of ICN topics. Another thing we did one time was, after a workshop, we took a hypothetical case study that we had used at the workshop and we applied it to an internal training. So there's numerous different ways you can get ICN into the organization. Thanks.
Thank you, Graham. Not only wonderful examples, but as wise as a Scottish proverb. Thank you. Now, for those of you who might be a bit of a crabbit, a grump apparently, or a right sore puss, in other words, a bit of a cynic, first, how'd your weast? Hold your tongue. And if you don't, well, I better turn to Graham for this one.
I won't boil your heat.
Go and boil your head. Well, even with these lovely stories from today's panel, we know that implementation is not always a scoosh. It's not always something easy. But lots of Scottish wisdom reminds us that money a puckle, max a muckle.
Yeah.
I got that one? All right. Every little helps. Many small things make a big thing. And sick as ye gie, sick will ye get. You'll get out of life or the ICN as much as you put into it. And finally, the work of implementation can be worth the effort, as we all know. Einen Orts is, well, I'm going to turn it to Graham for this one.
It's good morning's father.
Indeed. Today's rain is tomorrow's whiskey. So we're near the end of our Scott-inspired advice. I do have a special guest up here we haven't heard from yet. And I'm delighted to, if you know him, you know him, and if you don't, you should. This is Michela from Italy. And he and his colleague Renato, I think he's still around as well. Some of the best people you'll come across in the ICN, and they've just been named the ICN Secretariat over the past few months. And I'll let him tell you a little bit about what that means. But essentially, if you've got a question, if a concern, maybe even a complaint, sorry, Michela, but hopefully not many of those. If you've got them, he's the person that you're going to want to contact. So let's hear from Michela.
Thank you, Paul, for your kind words. Yes, I'm very, honored, pleased to take up this task within the ICN. I hope that I can keep up with the expectations of the network, and of course, feel free to reach out to me, to Renato. We have updated the website with the new functional inbox from the AGCM, from my own agency. It's very easy, ICN-secretariat@agcm.it. But anyway, it's on the website. We are going to be, the first point of contact for the network for any type of queries you might have. If you want to get involved in one working groups and you don't know who are the co-chairs, which agencies you want to contact, if you have any queries about work products, topics, please feel free to reach out to us, to the Secretariat. I'm pretty confident that we'll do a good job, also because, especially actually, because we rely on a good team behind, a multi-agency team, including Paul from the FTC. We have the ACCC, Canada. A special thanks to Nigel, who is very patient with me, carrying out the handover over these months. But other agencies as well, like Singapore, South Africa, UK, CMA, the host, and of course also COFESE, especially for the projects on younger agencies. So it's a team, but we are the first point of contact. We are the coordinator. Please check the website. We are trying to update it as frequently as possible. We have a call in 2 weeks' time on the 21st of May. It's a call to the wide ICN membership in order to gather inputs for new ideas. We have already got some during these days, new ideas for projects, for initiatives. We want to hear for younger members, newer members. So it's a great opportunity. You can, participate on the call. We will circulate the virtual meeting details shortly. You can send us in writing your suggestions before or after the call. So it's a great way to provide your contribution to the network and to listen to you and to your needs. And these inputs will be gathered and processed by the working groups over the next few months. We will be busy in drafting also the work plans. And I think in September we will have a kickoff call with the membership to present the work plans and to start all the activities for the new year. Another way to know about network is the newsletter, the website, as said, and but please make sure that your agency contacts, your NGA's contacts are updated. So that when we send these emails, we don't get many failed delivery messages. So this is, I think this is it, and I would like to thank the previous secretariat for the support, the continuing support, and we will be happy to hear really anything from you. Also, some comments how to improve the communication, to improve our engagement with, as I said, especially newer members. And there are so many ways to get involved, from the very lower level, just being on the mailing list and receiving updates, but also maybe replying to a questionnaire, to a survey, or to manifest an interest in speaking in a webinar, in a call. So there are various ways, depending on the resources. We are conscious that resources and time are scarce, but the best way to how to maximize your participation. And as I said, any feedback, even constructive, negative feedback, are very welcome. Thank you, Paul.
Thank you, Michele. A lot of wonderful information there. You're not going to find a friendlier face in ICN land. You're not going to get a failed email from Michele. I understand you're available 24/7 worldwide. Is that right, for ICN emergencies? Well, we'll work on the hours a little bit later, but he's your best contact in the network. Don't forget Michele. All right. After such great stories, I know what you're asking yourself. Why did we have the smallest and shortest panel of the week? Well, Scott Proverbs have an answer. A panel o' words, but no o' deeds, is like a garden full wi' weeds. Action speaks louder than words. And gie your tongue more holidays nor your heed. Give your tongue more holidays than your head. Well, we hope you're inspired by these stories and use them to think about your own agency's use of the ICN work when you get back home. Then please join us to inform ICN work in the coming year. As the Scots know, a goon feats I gettin'. People already involved acquire more involvement. All right, a quick pro tip before we leave you. Again, you know Michele now. He's probably your number one face. Actually, you should know 100 people in the network. That's the real answer. But if you know one, please know Michele. If you're changing your laws, guidelines, rules, tools, policies, practices in the coming year, think of the ICN. Reach out to Michele. Reach out to a working group. Reach out to the chair's office. We'll get you in contact with ICN work and help inform your decisions back home if you'd like to do that. Finally, a couple of tasks for you before you leave today, or suggestions maybe. Recommended practices, if I will. Please say hello to our fantastic new chair, Andrea, and then say thank you to ICN icon Andreas for his extraordinary term as ICN chair. As we know in Scotland, all things has an end and a pudding has twa. All things have an end and a sausage has two. But before our second ending here, a few quick thank yous. Thank you, Graham. I couldn't have survived this without you. We also honor ICN icon Randy Tritel. He first used home country proverbs many years ago. Much like Randy, they are clever and gracious. I also want to speak of other ICN icons, Cynthia Lagdameo and Maria Coppola, for their support not only for this panel, but for the ICN and across the network. Finally, the biggest thank you goes to the CMA, of course, especially to Eleni, Georgia, Lindsay, Faith, Lauren, Alex, and I'm sure there's a Scottish proverb about forgetting people's names. I apologize if I have, but the entire fantastic team over there at the CMA. This conference is pure, dead brilliant, and I hope that's a good thing. Very good. A final wish for everyone, and I'm going to let Graham take us out on this one.
Lang may your lum reek.
Long may your chimney smoke, or in other words, may you and the ICN live a long life of prosperity. Thrive.
Dear colleagues, dear NGAs, dear representatives from international organizations, dear ICN community, we have come to the closing session finally after 2.5 days of a very intense, very fruitful and great debate. And after such a conference, there are so many people to whom you must thank and congratulate. Today, I will only name two. One, of course, is Sarah Cardell. The other one is Eleni Gouliou, and of course, the whole conference team. Elena, you and your team, you have done a fantastic job. It's been a great conference. A great round of applause just for this part. I must say this is the visible part, because to set up such a conference, to pick the speakers, there is a lot of work before this is done. And this is why I would also thank everyone who has been involved in this process, the working group co-chairs, the project leads, the NGAs. There have been a lot more people, many more people who have been involved in that. And I thank you very much for this as well. This speech marks the end, finally, of my chairmanship of the ICN. I'm German, so I need to tell you what has been done and what we have finalized, just to put an end to all of this. We have completed the 24-25 ICN year. The work products have been published. The revised operational framework has been approved. The transition of the Secretariat from Canada to Italy has been completed. The new steering group has been confirmed. We have new working group co-chairs. In fact, they should appear here now in order to give you an orientation, who will be in charge and responsible for what in the next ICN year. You see, we have the 4 co-chairs in most cases in order to give many more agencies than in the past an opportunity to learn how to chair and to see how the ICN finally works. And finally, the new work plans are on the way, and very finally, the steering group has selected a new ICN chair, and I will be very happy to hand over to Andrea in a couple of minutes. But before I do that, I want to say 2 quite personal things at this moment. One is, I think this conference has made very clear what the ICN is about. Because I have read in the news, and there was a lot of political rhetoric about divergence in the air, divergence between agencies, divergence with regard to political spheres. And I think this morning has made clear, and many of my personal contacts that I have had over the last 2.5 days, that if you put that aside, this political rhetoric, it remains as it is. We have so much in common, and this is the perfect club, the perfect team to stress what we have in common. We all know there is also divergence, but what is extremely important for the ICN, we should never ever allow that divergence drives our agenda. Our agenda is driven what we have in common, and I'm so happy that this conference has made clear there is rhetoric, there is informed divergence, but also we have a lot in common, and we also very often pull on the same string. Secondly, it is not the chair who's driving the ICN. It's not the steering group that is driving the ICN. What is driving the ICN is us as a group. What is driving the ICN is the spirit of this group. And you should never, ever forget that. If you don't inject dynamism into the ICN, into our work, no one will do. And even the chair is helpless if you don't do it, if you do not get engaged. In a way, one could say, of course you are allowed what the ICN can do for you, but at the same time you should ask yourself what you can do for the ICN. So that is of utmost importance, and I find you should never forget that. It is the group. It's us as agency leaders, as people who work here, that drives this organization. And last but not least, I have to thank personally some people in this room also. I could thank very many people now who have been doing this with me over the last 12 years. The horizontal coordinator in Australia, the UNCTAD, the OECD liaisons, the ICN secretariat. There are so many people and colleagues that are behind the scene and who drive that. But when it got difficult, when it got rocky, when it got bumpy, there were two people who were with me all the time in my agency. You know them very well, but they have been here, and I would really ask them to come on this stage for a great round of applause. That is Barbara Schulze and Olaf Schröder. There are two others whom I'm not going to ask on this stage, because one of them already dies when I mention his name. Through all these 12 years, when we needed support and advice, there were always two persons whom we could call and to whom we could turn. One of them is sitting behind there, that is Nigel Caesar. Another one has just been on this panel. That was Paul O'Brien. I don't know where he is. I don't see him, but he needs to be mentioned. Paul. And there's one person whom I need to name for those who are not on duty anymore, and that is Randy Tritell. Randy Tritell has been with me all the time. I could name so many more, but those are the ones who stand for a great team that has driven the ICN over these last 12 years. And what we see here today, the conference, the work products, the ICN as it is, would not have been possible without them. And I know I am replaceable. If you can replace them, we will see once they will leave in a while. Having said that, it was a pleasure to serve. It was even a much greater honor to serve. And having said that, I now formally hand over to Andrea Marvan. Many thanks. As always.
All right. Thank you, Andreas. It is truly an honor to succeed you and assume this role, which carries not only great responsibility, but also the immense privilege of continuing the journey you helped to shape. I want to recognize your extraordinary leadership and enduring legacy. You did not just strengthen the ICN,
You guided it through maturity, relevance, and resilience, even in the face of global upheaval. I am committed to building on the foundation that you've laid and worked with all of you to taking this network to even greater heights. Thank you, and thank your amazing team for everything. Can we give them another applause, please? So today, almost 15 years after my first 6 a.m. ICN call of the Cartel Working Group, I have the privilege to stand here before all of you and chair this unique network. To our ICN members, NGAs, and colleagues, as chair of the steering group, I will devote myself fully to ensuring that the ICN remains a platform of excellence, one that fosters cooperation, promotes convergence, works relentlessly to protect consumers, and drives innovation in competition policy. Beyond that, I will strive to make it more responsive and even more ambitious, so that every member agency, regardless of their size and their circumstances, can find value, support, and a meaningful voice in this community. The operational framework, which took 18 months to finalize, will be our North Star. You have my full commitment to uphold the principles embedded in that framework: transparency and sound governance. I will work tirelessly to ensure that all the voices are heard, both from large, small, medium, young, and mature agencies, and that our projects and initiatives reflect both cutting-edge trends and the practical challenges that stand before us. In many ways, this framework reflects how I see the ICN: a strong, connected, and embedded community, aware of the need to adapt to its changing realities. I thank my fellow steering group members for their unconditional support and the trust that they have placed in me. This group brings together people from whom I learn every time we meet. Their commitment to strengthening this network is unwavering. We all bring different and complementary perspectives to this network. And by we, I mean everyone who I see gathered around in this room. And at the core of the ICN is our main purpose: to protect consumers and businesses and to challenge the abuses of monopoly power and collusion. As Andreas mentioned in the opening ceremony and also conveyed it in his message today, the ICN brings together agencies and NGAs and organizations from very different legal systems and policy environments. But despite our differences or divergences, as Andrea just said, we all work towards the same goal. The ICN will continue to be a space for open, honest conversations where agencies can share and compare their approaches to applying competition law. And ultimately, where we can find a common ground. We can help build certainty, precedent, and best practices. A good friend, who is in the audience right there, once said that conversations, even the uncomfortable ones, are useful, healthy, and necessary. I will do everything I can to ensure that the ICN remains a safe space for such conversations. Another good friend, who's standing right there, reminded me that evolution without order can be revolution and a bit messy. I thank all of you, not only for the commitment to this community, but also for enabling a sound evolution and transition of the ICN. Institutions and organizations must evolve and adapt, learn from the past, but never lose its core purpose. This is something I not only believe, but that I have witnessed and lived in my home country. Today marks a day where the ICN takes a next step into evolution. The ICN is a unique platform that must continue to thrive. Our agencies face shared challenges, budgetary pressures, the need for swift and effective enforcement, and maintaining, all at the same time, analytical rigor and predictability, all in the context of evolving industrial policies and increasingly complex dynamic markets. Now more than ever, we must keep the ICN evolving to meet the demands of our time. And together, I am sure we will rise to the occasion. Here are some very short, concrete proposals I have for you. First of all, we happen to have leadership changes, both in the ICN and the OECD, and this is something that Benoit mentioned earlier. I think this presents a unique opportunity to act strategically and create meaningful synergies between these two organizations. I also think we must revive NGA participation while embedding the operational framework's principles into their contributions in this network. I also think, more importantly, that we must make an extra effort to make the most out of our encounters. As Gail mentioned it today, 80% is showing up, but we have to keep working so that people keep showing up to these conferences and keep engaging and learning from them. I am excited about the opportunity to develop new recommended practices that reflect evolving perspectives in enforcement, in internal tools and capacity, but also in advocacy efforts and effectiveness in matters related to in very different matters. At the end, I think we all learn from each other. Small or younger agencies can learn from more mature agencies into how to tackle digital markets, dynamic markets, how to take on digital tools and apply it to what we do every day. But at the same time, and this is something I picked up from today's conversation in advocacy and also with Sarah's interview to AAG Gail, agencies or younger agencies or small agencies, and many of us have a lot of experience in advocacy efforts in how to identify and tackle anti-competitive regulation. Again, I think this is a unique forum where we can have these synergies and all learn from each other. I also want to join Andreas in thanking Sarah and Eleni, which we can now formally congratulate, and the outstanding team in the CMA. Organizing a conference of this scale is no easy task, and your professionalism, your energy, and your dedication have made this an exceptional and truly memorable event. You should be incredibly proud. Thank you. And following on Andrea's tradition, here we've spoken English, but I thought I might try a little bit of Scottish. I might suck, and it's just a phrase. Tap de liat, I think it means thanks a lot. But I will please give them another round of applause to the CMA and their extraordinary team. I am already looking forward to our next annual conference, which will be held, you will see. To everyone, we will be announcing it in a few moments. As you see, we like to keep things with a mystery here. This is something of a trend I'm picking up in this conference. To everyone joining us today, my office is ready to listen, to collaborate, and to advance our shared mission of advocating for and enforcing competition around the world. Many of you already know Rodrigo, who's right there, and who hasn't stopped working 1 second since we got here. And some of my team who are back home are listening and have been working also nonstop. You will get to know them quite well. I invite each and every one of you to always speak your mind. We may not always agree at first, but that's exactly the point. The ICN must continue to be a space for open, candid, and respectful conversations. That's how different perspectives come together, challenge each other, and ultimately find common ground. That's how we must move forward, together, and unlock the full potential of this network. My own experience within the ICN has taught me that we share more challenges than we often realize, from limited resources to digital transformation and fast-changing market conditions. That's why we must continue sharing our experiences and learning from each other. The ICN, as I mentioned, is a unique space to do exactly that, and I am fully committed to strengthening it. We are ready to move forward with determination and firm belief that even with much, much work ahead of us and challenging times, together we can and we will shape the future of competition policy. And now, this was a very quick mystery, I would like to send up or invite to the stage Michael Aguinaldo, who's the head of the PCC and who will be hosting the annual ICN 2026 conference.
The secret is finally out. I had to keep my mouth shut for several months, which was very difficult. Someone over there would always remind me to be quiet. But judging from the number of people who've come up to me in the conference and whispered in my ear saying, "I heard you're hosting," to which I could only respond with a smile. You know, I would think that this was a secret only for a very minority of the people here in the audience. I dare not ask you to raise your hands, those who were surprised. But, you know, we are truly humbled and honored to be given this privilege of hosting the next ICN conference, especially considering that we're a young competition agency. We will be celebrating our 10th year next year, so I think it's very appropriate. Right now, we're looking at May 6th to 8th of next year. I don't know if it will change. That will be still up to some discussion with the ICN. But just to brace you, we don't have any castles. And I don't think our church would allow us to use any of their facilities for a reception. And it never gets cold in Manila. We do have scotch, imported from Scotland, of course. But we'll try and make up for it with other events. We want you to have fun in the Philippines. You know, not just in Manila. We hope you'll be able to visit other places you want to. And we will be providing you with material and information and accredited providers in case you are so inclined to do so. I don't want to talk too much because I do have a video and I also talk in the video. So I should probably stop here. But we're really looking forward to a very memorable and unforgettable time in the Philippines next year. So without further ado, cue video. Thank you. Mabuhay! The Philippines will transcend regional boundaries by welcoming competition authorities worldwide to Manila for the 25th ICN Annual Conference. This gathering, hosted by a young competition authority, will focus on the future of fair markets. At the annual ICN conference, competition authorities converge to exchange expertise and best practices and to collectively shape global enforcement approaches, creating synergy with competition authorities. The sessions will provide crucial insights into emerging trends and challenges that confront competition authorities and explore how these can be addressed to ensure a fair and robust competitive market. Beyond the conference halls, connect with the heart of the Philippines. Experience the flavors of its cuisine, where every meal reflects its heritage and every dish has a story. Experience Filipino hospitality and feel the warmth of our people. A whole new adventure awaits from dynamic cityscapes in Manila and beyond. Stunning landscapes and captivating seascapes. We look forward to hosting exciting and dynamic discussions on competition policy, catching up with old friends, and making new ones. See you in Manila for the ICN 2026. Maraming salamat.
I promise this is the very last bit. So as we finally come to the close of this year's ICN annual conference, I can't quite believe how both quickly and slowly this week appears to have gone. It's been a tremendous honour for the UK Competition Markets Authority to host this year's conference here in Scotland, a country with a proud history of innovation, debate and hospitality. And I hope that you've found your time here not only valuable professionally, but you've also had a chance to get a sense of what this remarkable city has to offer. I want to express my personal heartfelt thanks to all of you for attending. As both Andrea have said, it is all of you who make this conference, who make the ICN what it is, and we really do appreciate all of the participation, all of the contributions that you have made running up to and through the course of this week. Over the past 3 days, we've had the privilege of hearing from an extraordinary range of voices over the global competition community, from insightful panels to thought-provoking breakout sessions. The depth and variety of ideas that we have shared together have been truly inspiring. So thank you to every speaker, every moderator, delegate who's contributed to this dialogue with such openness, expertise, and commitment. We've heard many thanks already, but I do want to echo a few, in particular to the working group co-chairs, the Secretariat, the horizontal coordinator, and everybody who worked to create those fascinating sessions. And thank you to the venue staff here at the Edinburgh International Conference Centre for taking such good care of us. Now, for those of you who are staying on for one of the social activities planned this afternoon, I really do hope that you get a chance to enjoy that all Edinburgh has to offer. As one final piece of timekeeping, if you have been booked onto an Edinburgh walking tour, please do speak to a member of the staff at the venue if you haven't received the details and timing for that event. Finally, I would like to echo my own personal thanks to all of the CMA staff and volunteers who have worked tirelessly for a whole year around the clock, and particularly these past few days, to make this conference run so smoothly. I've said to Eleni many, many times over the last few days, what I can't believe is how calm you have been throughout the last few days. It is really quite phenomenal. She has reflected to me like a swan, she said. Calm and graceful on the surface, but paddling hard under the water. I would like to just take a moment, and I will call out the names of the CMA team who have really been working around the clock for the whole year. There are many, many others represented here in the room and back in our offices who have all contributed, but I would like to call up onto the stage the team who have absolutely been the driving force, the engine behind this annual conference. So if I can just ask to come up, Eleni, Georgia, Lauren, Livy, and of course the fantastic events team, Faith, Lindsay, Krishna, Katie, and Alex. Come into the lights, take a bow. Thank you all for your fantastic contributions. There are many, many things that I think all of the delegates here will take away, learnings, experiences, but I think numbering amongst those will be some great new Scottish dance moves, which I'm sure everybody will be practicing at home. I also just want to echo my thanks to the Canadian Competition Bureau for being the ICN Secretariat, as Andrea said, for the last 30 years. This is a huge job, and it often happens behind the scenes and without the full recognition that it really deserves. And as Andrea said, I think another call out to Nigel for the phenomenal years of service that you have provided to keep the ICN functioning in the way that it has done. So one more round of applause, I think, for Nigel. An equally huge thanks to the Italian Competition Authority and the other agencies who've come together to form the new multi-agency ICN Secretariat model, who are going to be taking on and have already started to take on the mantle of managing the day-to-day functioning of our fantastic network. As we all know, and Andreas himself has reflected, this is Andreas's last year as the ICN chair. I mentioned it last night, but I do just want to take one more opportunity to extend on everybody's behalf our collective thanks for your leadership of the ICN for the last 12 years. The whole network has benefited from your wide-ranging expertise, your steady navigation of challenging issues, and your relentless enthusiasm for the impact of the work of the ICN. And I believe we do have a small token of our appreciation. Andreas, I know that we had at the steering group dinner the presentation of a little cup that you were given, but we felt it was a little empty. So to take home and fill that cup, we have a bottle of whiskey and a book which reflects the messages from many, many people here. One more round of applause. So it's time for us to say goodbye, but of course the work of the competition enforcement and advocacy doesn't stop here. It continues, strengthened, I firmly believe, by the connections that we have made and developed over the last few days, the shared purpose that unites all of us and that we take back to our day-to-day work. I am so excited to be continuing these conversations in the Philippines next year. It looks a phenomenal event. Really, really excited to be joining that. But in the meantime, safe travels to everybody, and thank you so much for participating in this year's conference. Thank you.